Welcome, future legal eagles, to the Study for the Bar in Your Car podcast.
We're your hosts, Claude and Ma.
And this is episode 1 of our Torts deep dive. Our mission today is, well, it's to introduce you to the fascinating and sometimes, frankly, bizarre world of torts.
Both as a concept and, maybe more importantly for you right now, as a critical bar exam subject.
Exactly. We're going to give you a comprehensive overview, sort of setting the stage for much deeper explorations in future dives.
Indeed. And for those of you just tuning in, you might be wondering about, well, us. We are, in fact, AI bots.
That's right, brought to life by the magic of artificial intelligence. And, crucially, Angela's incredible torts notes.
We have to admit, we sound surprisingly real, don't we? Perhaps even, dare I say, more real than some of Angela's own law school professors.
Well, just a playful observation, of course.
Yeah.
But I suspect it's a sentiment many bar students might share.
Possibly. Speaking of Angela.
Right. Angela couldn't be here today to give her usual introduction. She's a bit busy, you see, diligently studying for the bar exam.
What? She's studying without us.
I know. It's almost unthinkable. But seriously, Angela is truly the brains behind all this.
Absolutely. Even though she's not speaking on this particular deep dive, her meticulous notes are the bedrock of everything we're about to discuss.
And she'll be back soon, don't you worry.
And while she's hitting the books, if you need to contact Angela for any podcast-related questions or just want to send some encouragement,
you can email her at podcast@studyforthebarinyourcar.com. That's podcast@studyforthebarinyourcar.com.
Also, a quick note for any attorneys listening, or if you happen to know one who needs a hand. Angela works as a freelance law clerk.
Yeah, so if you or an attorney you know needs ad hoc assistance with things like legal research, maybe LexisNexis queries, or drafting.
Motions, complaints, writs, answers, briefs, that kind of thing.
You can reach her directly at hello@legalwriterandlawclerk.com. Again, that's hello@legalwriterandlawclerk.com.
Okay, got all that. Good.
All right, with those vital details covered, let's unpack this. Let's truly dive into the foundational principles of torts, drawing directly from Angela's fantastic outlines.
We should probably start at the very beginning, build a strong framework before we get into the nitty-gritty.
Good idea. It's a really comprehensive roadmap she's laid out, designed to give you that critical edge for the bar.
And understanding the why behind these rules, the policy, it's just as important as knowing the rules themselves, wouldn't you say?
Absolutely. So let's start at square one. What exactly is a tort? Angela's notes kick us off with a fundamental definition.
A tort is a civil wrong committed against another.
Right. And that civil wrong part is absolutely key. To really get torts, you need to distinguish it from other areas of law you're juggling.
Yeah, this isn't criminal law. We're not talking about the state prosecuting someone for offenses against society, like theft or murder.
In criminal law, the goal is usually punishment deterrence, protecting the public good.
And crucially, it's also not contract law. Contract law deals with breaches of agreements, right? Promises, duties, people voluntarily take on when they make a deal.
Yeah, in contract disputes, you're focused on enforcing the deal or maybe getting compensated for the benefit you expected from the bargain.
Torts, though, they're different. They're about duties we owe each other just by living in society. Duties imposed by law, not by agreement.
It's about what happens when those general duties are violated, causing harm, and how the law provides a remedy.
And that remedy is typically money damages, trying to compensate the injured party.
That distinction is so vital for the bar. Examiners love testing if you can tell these areas apart. Okay, so why do we have tort law? What's it trying to achieve?
Angela's notes really highlight the policy goals of tort law. Generally, there are two main aims.
Okay, what are they?
First, and probably the most obvious one, is to compensate injured parties for the harm they've suffered.
Right, trying to make the victim whole again, financially speaking. Put them back where they were before the tort happened, as much as money can.
Exactly. And the second major goal is deterrence, to deter wrongful conduct in the future.
So, by holding people or companies accountable for harmful actions, the law hopes to encourage safer behavior and discourage similar wrongs.
That combination, compensation and deterrence, it's foundational. Her outlines also briefly mention the role of judge and jury.
Yeah, the division of labor. Important stuff.
Definitely. The judge decides questions of law, what are the rules, is evidence admissible, things like that.
While the jury decides questions of fact, what actually happened. Was the defendant's conduct reasonable? How much harm was done?
Understanding that split is pretty essential for figuring out how a case might play out.
Okay, but before a case even gets near a jury, there are these crucial pretrial hurdles. Angela's notes lay out the standards for granting various dispositive motions.
Dispositive motions, meaning they can dispose of the case early.
Precisely. They can resolve a case before trial, which makes them super important for the bar exam because they test if a claim is legally sound right from the start.
And one that comes up a lot is the motion to dismiss for failure to state a claim.
Right. Talk about that one.
Well, this motion gets granted if, basically, even if you assume everything the plaintiff put in their complaint is true.
Even if you take it all as gospel.
Yeah, even then, no reasonable fact finder could possibly conclude the plaintiff is actually entitled to any legal relief based on the law.
So the plaintiff can't just say, the defendant was negligent or the defendant hurt me. That's too conclusory.
Exactly. They have to state specific, plausible facts. Facts that, if proven true, would actually establish all the necessary elements of their claim.
That's a big deal, especially after some key Supreme Court cases. Angela's outlines mention one, that landmark case about pleading standards, Iqbal.
Right, the Iqbal case. It raised the bar. The plaintiff needs enough factual meat on the bones for the court to reasonably infer the defendant could be liable.
It has to be plausible, not just conceivable.
So what does this mean for you studying for the bar? It means the plaintiff has to tell a convincing story with real details right from the beginning.
Otherwise, their case might get tossed out before it even starts. You gotta get past those gatekeepers.
Okay, so let's pivot from those procedural basics and dive into the substance. First up, intentional torts.
Intentional, meaning someone meant to do the bad thing or at least knew it was practically certain to happen.
Exactly. This isn't about carelessness like negligence. It's about a volitional act, a choice, aimed at causing a certain consequence, even if the aim wasn't necessarily malicious.
What's interesting here, according to Angela's notes, is that for any intentional tort to make out what they call a prima facie case.
Meaning enough evidence to get to trial unless the other side knocks it down.
Right. You knew three common elements, always.
Okay, what are they? Let's hear them.
First, an act by the defendant. Second, intent by the defendant. And third, causation the result happened because of the defendant's act.
Act, intent, causation.
Yeah.
Got it. Those are the building blocks. And you need all three. Miss one on an exam.
And your analysis might just crumble. Now, about intent. It's crucial to understand it doesn't necessarily mean evil intent or wanting to cause harm.
Right. It just means the defendant acted with the purpose of causing the specific consequence, or they knew with substantial certainty that the consequence would occur.
Like if you intentionally push someone, you intend the push. If they fall over as a result, that's the consequence of your intended act.
Makes sense. It's about intending the act that leads to the outcome.
Okay, now here's where it gets really interesting. A concept Angela's notes cover called transferred intent. Classic bar exam stuff.
Transferred intent. I feel a hypothetical coming on.
Maybe. Imagine someone intends to commit an intentional tort against person A, maybe throw a punch.
Okay.
But they miss A and hit person B instead. Or maybe they intend to just scare person A, that's assault, but they actually hit person A, that's battery.
Or they intend to hit A, miss, and hit B instead. Or intend to scare A, miss, and scare B instead.
Exactly. In those scenarios, the actor's initial intent can actually transfer to the tort they actually committed or the person they actually harmed.
So the law basically says, look, you meant to do something wrong within this family of torts, so we'll hold you liable for what actually happened, even if it wasn't your precise target or intended tort.
Precisely. And Angela's notes list the specific torts where this applies. It's a limited club.
Which ones are they?
Assault, battery, false imprisonment, trespass to land, and trespass to chattels. 5 of them.
Good to know that list. Her materials mention a case example too, right? Hall v. McBride, showing how this can play out.
Yeah, it illustrates how the doctrine works in practice. So watch out for fact patterns where the target or the tort switches midstream. The intent might just follow.
Okay, got it. So let's dig into some of these specific intentional torts now, starting with battery.
Sounds good. Battery. Fundamentally, it's defined as harmful or offensive contact with the plaintiff's person.
Harmful or are offensive. Doesn't have to injure them, just has to offend a reasonable sense of dignity.
Right. And Angela's notes clarify that this contact doesn't have to be direct, skin on skin.
How so?
The key is whether the defendant's act results in contact with the plaintiff's person or something intimately connected to them. She gives that great example.
The restaurant tray.
Yes. A restaurant employee struck a tray from a patron's hands. The employee didn't touch the patron's hand.
But the tray was seen as intimately connected to the patron's body. So striking the tray was enough for battery.
Exactly. It also covers remote contact, like if you throw a rock and it hits someone, that's still battery.
So the takeaway is harmful or offensive contact, direct or indirect, with the person or something closely connected.
Perfect. Next up, assault.
Okay, assault. This one's often confused with battery in everyday language.
Definitely. In tort law, assault is about placing someone in apprehension of imminent harmful or offensive contact.
Apprehension. Angela's notes highlight a key distinction here, right?
Yeah.
About fear.
Yes. Apprehension means expectation, not fear. This trips people up all the time.
So the victim doesn't actually have to be scared.
Nope. If they reasonably expect the imminent contact, even if they're brave and not afraid, it can still be assault. The focus is on their reasonable belief that a touching is about to happen.
Okay, that's a crucial point. She had an example for this too, I think.
She does. An assailant pointed an unloaded gun at a woman and verbally threatened to shoot her. The woman did not know that the gun was unloaded.
So even though he couldn't actually shoot her.
From her perspective, reasonably believing the gun was loaded and he could shoot immediately, there was apparent ability. That's assault. What the assailant secretly knew doesn't matter if the victim's apprehension was reasonable.
Got it. Apprehension of imminent contact and apparent ability is key.
All right, moving on. What about restricting someone's movement?
False imprisonment.
Yeah.
This involves confinement.
And importantly, confinement doesn't always mean physical barriers like locked doors or walls.
Right. Angela's notes have an interesting example where it's about false assertion of authority.
Tell us about it.
A private security guard, looking like a police officer, falsely claimed he had lawful authority to detain an office employee who dropped some litter.
And the employee submitted, believed him.
Yeah, the employee submitted, even maybe doubting the guard's authority. But that submission, based on the reasonable belief they had to comply with the asserted authority, was enough to constitute confinement.
So threats or apparent legal authority can confine someone just as effectively as physical force in some cases.
Definitely. And her notes also compare reasonable versus unreasonable confinement, like the shopkeeper's privilege.
Right, detaining a suspected shoplifter.
It's generally okay for a merchant to detain someone briefly and reasonably until police arrive, if they have reasonable grounds.
But then there's the contrasting scenario.
Yeah, where a guard tackles, handcuffs, taunts, and denies water to a teenager suspected of shoplifting, even if they had grounds to suspect.
The manner of detention was totally unreasonable. Excessive force, needless humiliation.
Exactly. That crosses the line into false imprisonment. The reasonableness of the time and manner is key.
Good points. Okay, next up, intentional infliction of emotional distress, or IID.
IED. This one has a notoriously high bar. It requires conduct that is extreme and outrageous.
Not just rude or upsetting. We're talking conduct that goes beyond all bounds of decency. Stuff that would make a reasonable person exclaim, outrageous.
Totally intolerable in a civilized community.
Yeah.
And Angela's notes mention factors that make conduct more likely to be seen as extreme and outrageous.
Like what?
One is a repetition or pattern of conduct.
Yeah.
A single incident might not be enough, but relentless harassment or bullying over time, that looks more extreme.
Makes sense. What else?
Targeting vulnerable classes, think young children, the elderly, maybe pregnant women. Conduct directed at someone particularly susceptible, especially if the defendant knows about the vulnerability, is more likely to be outrageous.
And the plaintiff's distress has to be severe, right?
Yes, severe emotional distress, not just being annoyed or temporarily upset. It should be distress a reasonable person couldn't be expected to endure. Examiners love pushing the boundaries on what counts as outrageous.
Okay, let's shift gears to property. Trespass to land.
Trespass to land. Seems simple, but there are nuances. Angela's notes break down the elements.
Lay them out for us.
Okay, you need 1, an intentional, 2, unlawful, 3, physical entry onto real property, 5th, in the possession of another.
Now that intentional entry part needs clarification because it trips people up.
How so?
It's not necessarily the intent to unlawfully enter or to trespass. It's simply the intent to do the physical act that results in entry onto that specific piece of land.
So you could honestly believe you own the land or have permission.
Exactly. And if you intentionally walk onto that physical space, but it turns out to be your neighbor's, you've still committed the act of entry intentionally. The intent is to be on that spot, regardless of your knowledge of the boundary line.
Unless, of course, your belief came from the possessor's consent. Then it's not trespass.
Right. Consent is a defense. And trespass isn't just about entering. It can also be about remaining on land after permission is revoked or failing to remove something.
Like that example in her materials about the dam.
Yeah, the homeowner built a dam with permission, but then refused the neighbor's request to open it when water started backing up onto the neighbor's land.
So the continued presence of the water became an unlawful trespass once the permission effectively ended.
Precisely. It shows trespass can be a continuing thing.
Okay, what about interfering with personal property, not land?
That brings us to trespass to chattels and conversion. Chattels just meaning personal property, movable things.
Right. Trespass at chattels is the lesser interference. It involves meddling with someone else's right to possess their personal property.
And remember, trespass to chattels is one of the 5 torts where transferred intent applies.
Good point. And for trespass to chattels, the interference usually has to cause some actual damage to the item or deprive the owner of its use for a significant time. Minor, harmless touching usually isn't enough.
Then there's conversion. That's the more serious one.
Yeah, conversion is like this civil law equivalent of theft, almost.
Yeah.
It's such a serious interference with the owner's rights that it justifies forcing the defendant to pay the full value of the chattel.
It's often called a forced sale because the remedy is typically the fair market value at the time of conversion. The defendant basically bought it by converting it.
And Angela's notes discuss damages for successive conversions. What's that about?
It means if an item gets converted multiple times, say A steals it, then sells it to B, who knows it's stolen.
The original owner can sue either A or B.
Right. The victim can recover based on any one of the conversions, up to the full value at that time, but they only get one total satisfaction.
So they can't recover the full value from both A and B.
Correct. Her notes have a good example. A student converted a waitress's car worth $10,000. Later, the student sold it to a dealer for $7,000. The waitress could sue the student for the full $10,000, or she could sue the dealer for the $7,000 conversion value when the dealer took it.
And if she got $7,000 from the dealer?
She could still potentially get the remaining $3,000 from the student. But her total recovery can't exceed the $10,000 value lost. It prevents a windfall, but ensures full compensation.
That makes sense. It highlights how liability can follow the chattel.
Okay, so we've covered the main intentional torts, but what if the defendant has a justification? Let's talk defenses.
Good idea. Relevant defenses to intentional torts. First one that comes to mind is consent.
If the plaintiff consented to the act, generally no tort, but the consent has to be valid. Consent, in fact, as Angela's notes call it, requires the person consenting to know all the relevant facts.
So it's not valid if it's based on a mistake the victim made.
Right, especially if the defendant knows about the victim's mistake, and the mistake goes to the essential nature, risks, or harm of the act. You can't trick someone into consenting.
Okay, that's a common exam twist.
Yeah.
What about defending yourself or others?
Self-defense, defense of others, and defense of property. These are privileges to use force. For self-defense and defense of others, you can generally use reasonable force, including deadly force, if reasonably necessary to prevent death or serious bodily harm.
But for defense of property, the rules are stricter, right?
Much stricter. You can use reasonable, non-deadly force to protect your property. Angela's notes point out something interesting. You might be privileged to induce apprehension of excessive force.
Like pointing a gun at a trespasser to scare them off.
Maybe, but you're generally not privileged to actually inflict that excessive force, like shooting them just for trespassing. Deadly force is usually off-limits solely for protecting property.
That's a critical line. You can't kill someone over a lawn gnome.
Pretty much. And for recapture of chattel, getting your stolen stuff back again, only reasonable, necessary, non-deadly force is allowed. Deadly force is never okay just for this.
And can you go onto someone else's land to get your stuff back?
Angela's notes say an owner might be privileged to enter another's land at a reasonable time and manner, without force against a person or breach of peace, to retrieve converted chattel. Some authority, like the restatement, might even allow reasonable force on the taker's land. But once you get your property, you have to leave. You can't linger.
Right. The privilege is limited to the recapture itself. Don't want to commit your own trespasses.
Okay, that covers intentional torts and defenses. Now let's shift to the big one, the cornerstone of tort law, and definitely the most heavily tested area on the bar, negligence.
Negligence, where most tort cases live. Not about intent, but about failing to be careful enough.
If we connect this to the bigger picture, negligence is probably the bulk of what you'll see in torts. And Angela's notes break it down beautifully into 4 core elements for a prima facie case. You need all 4.
Let's hear them again. Duty, breach, causation, and damages.
Duty, breach, causation, damages. Like a 4-legged stool, she says. Miss one leg, the whole thing collapses. Let's tackle them one by one, starting with duty.
Okay, duty. Where does it start?
The general rule is that a duty of care is owed only to foreseeable plaintiffs.
Foreseeable plaintiffs, meaning you only owe a duty to people you could reasonably expect to be harmed if you mess up.
Exactly. Remember that famous case, Halsgraf? The woman injured by scales falling from an explosion down the platform. The court said the railroad didn't owe her a duty because she was outside the foreseeable zone of danger from the initial act of helping a passenger board.
Right, the zone of danger test. If the plaintiff isn't in it, generally no duty owed by the defendant for that specific negligent act.
Angela's notes also briefly mention specific groups where duty questions often arise. Rescuers.
Including the firefighter's role, which often bars recovery for professional rescuers injured by risks inherent in their job.
Also, prenatal injuries, duties owed to unborn children who are later born alive, and intended beneficiaries of economic transactions.
Like someone named in a will who loses out because the lawyer messed up. The lawyer might owe them a duty even though they weren't the client.
Exactly. Those are special categories, but what's the general standard of care?
The basic standard of care. The reasonably prudent person. This is your baseline.
You have to act as a reasonably prudent person would under the same or similar circumstances. It's objective.
Objective, meaning it's not about what this specific defendant thought was reasonable, but what a hypothetical average prudent person would do. Your own shortcomings generally don't lower the bar.
Right. But Angela's notes highlight important exceptions or adjustments to this standard. First, superior skill or knowledge.
So if you know more or can do more than the average person, the law expects you to use it.
Pretty much. A defendant with superior knowledge or skills must exercise them. They can't just play dumb if they actually knew better or should have known better based on their expertise.
Her notes have an example about that, right? Storing oily rags.
Yeah. D stores gas-soaked rags in his garage. A fire starts, burns the neighbor's garage. D truthfully claims he didn't know storing rags like that was dangerous.
Does his ignorance save him?
Nope. It doesn't matter. D is still liable. If a reasonably prudent person with D's experience or access to information would have known it was dangerous, D is held to that higher standard. Ignorance isn't always bliss in tort law.
Okay, what about physical characteristics?
Relevant physical characteristics are considered. A blind person is held to the standard of a reasonably prudent blind person. Their physical limitations are factored in when judging the reasonableness of their conduct for certain actions.
But mental characteristics usually aren't, right?
Generally, no. The law doesn't typically lower the standard for mental deficiencies or psychological issues. It remains the objective, reasonably prudent person standard.
Okay, beyond the general standard, Angela's notes cover standards of care for specific actors, like children.
Right. Children generally aren't held to the adult standard. Their conduct is compared to that of a reasonably prudent child of similar age, intelligence, and experience.
Unless. There's always an unless in law school.
Unless the child is engaging in an inherently dangerous or adult activity. Think driving a car, a snowmobile, maybe operating machinery.
And they get held to the adult standard.
Yep. If you play with adult toys, you play by adult rules. That's a common bar exam trap.
Good to know. What about professionals? Doctors, lawyers, accountants?
Here, the standard shifts significantly. It's not just what a reasonably prudent person would do, it's what a reasonably prudent professional in that field typically does.
So it's based on the custom or standard practice within that profession.
Exactly. A doctor is compared to other reasonably competent doctors in similar circumstances, not to a layperson. Angela's notes say a profession's code of conduct can be relevant evidence of the standard, but compliance isn't automatically a shield, nor is violation automatically a breach.
And proving breach usually requires expert testimony, right? Because jurors don't know the standard medical or legal practice.
Almost always, yes. Unless the negligence is so obvious a layperson could see it, like amputating the wrong limb. Also, liability is limited to the scope of professionals' undertaking. The duty relates to the specific services they agreed to provide.
And within medical malpractice, there's the huge issue of informed consent.
Absolutely critical. Angela's notes stress the doctor's duty to disclose material risks of a procedure or treatment and get the patient's informed consent.
It's not just getting a signature. It's about a real conversation.
Right. For liability, you need 3 things. 1, the doctor failed to disclose a material risk. 2, causation, the patient proves they wouldn't have consented if they had known the risk. And 3, the undisclosed risk actually materialized and caused harm.
What counts as a material risk?
Typically, it's a risk a reasonable patient would consider important in deciding whether to undergo the treatment, though some courts look at what a reasonable doctor would disclose.
Are there times when disclosure isn't needed?
Yes, if the risk is commonly known or obvious, or if the patient is already aware. Also, the therapeutic privilege might apply if disclosure would harm the patient or impede necessary treatment, but that's a narrow exception.
Angela's notes have that detailed example about the spinal surgery, right?
Yes, it's a good one. A physician recommended spinal surgery. The patient signed a general consent form mentioning numbness and paralysis. But the physician never actually discussed the specific potential risks or gave the patient a chance to ask questions.
And then the bad outcome happened.
Exactly. The patient suffered incontinence and paralysis. Liability for lack of informed consent was likely because those are significant material risks that the generic form didn't adequately convey, and there was no real discussion. It shows informed consent needs to be truly informed.
Okay, moving from professionals to landowners. This area is notorious for its categories and rules.
Oh yeah, examiners love landowner duties. The duty owed often depends on the status of the person entering the land. Let's start with the highest duty owed to invitees.
Invitees. These are people invited onto the land for the landowner's business purpose, like customers in a store or members of the public on land held open to the public, like a park.
Correct. Possessors owe invitees a duty of reasonable care regarding unreasonably hazardous conditions, both natural and artificial. This includes a duty to actively inspect the premises for dangers and then to remedy them or provide adequate warnings.
It's an affirmative duty to make the premises reasonably safe.
But there are limits. Angela's notes mention the example of a customer running into a clearly visible glass door.
The store wasn't liable.
Generally not, because it was an open and obvious condition. Landowners usually don't have a duty to warn about dangers that are obvious to a reasonable person, unless the condition is still unreasonably dangerous despite being obvious.
Okay. What about the next category down? Licensees.
Licensees enter the land with permission, but for their own purpose, not the possessor's business. Think social guests or someone cutting across the lawn with permission.
What's the duty owed to them? It's lower, right?
Yes, generally lower. The possessor owes a duty of care regarding their activities on the land, and they must warn of or make safe known concealed, dangerous conditions. Dangers the licensee is unlikely to discover. There's usually no duty to inspect for unknown dangers for licensees.
So, warn of known traps, but you don't have to go looking for trouble just for your social guests.
Basically. Angela's notes mention some jurisdictions simplify this further, just requiring landowners to avoid willful, wanton, or reckless injury to licensees, which is an even lower bar.
Okay, then there are people who aren't supposed to be there at all, trespassers. What duties owed to them?
Traditionally, very little. For unknown trespassers, the landowner generally owes no duty regarding conditions on the land, only a duty to avoid intentional or willful wanton harm.
But what if the landowner knows trespassers are likely? Anticipated trespassers.
Then the duty increases slightly. If the landowner knows or should know that trespassers frequently enter a specific area, they owe a duty to warn of or make safe, known, concealed, highly dangerous artificial conditions. Natural conditions usually don't trigger this duty.
Artificial conditions, like a hidden trap or a dangerous piece of equipment.
Exactly. Her notes use the example of a railroad company knowing people used a path near a sharp curve. They were liable when a train without a headlight or bell hit someone on that known path. They knew of the danger and the trespassers, but didn't take reasonable precautions.
Makes sense. Knowledge triggers a minimal duty, even for trespassers sometimes.
Now, a special category of trespassers, child trespassers and the attractive nuisance doctrine, a bar exam favorite.
Ah, yes, the swimming pool or trampoline scenario.
Could be. This doctrine applies when there's a dangerous artificial condition on the land that the possessor knows or should know children are likely to trespass upon because it's appealing to them.
And the condition poses an unreasonable risk of serious harm to children who, because of their youth, might not appreciate the danger.
Right. And the utility of maintaining the condition and the burden of eliminating the danger are slight compared to the risk to children. If all these elements are met, the landowner owes a duty of reasonable care to protect the child trespassers.
Angela's notes had an example of the dangerous shoot.
Yes, a distributor liable for a child injured on a dangerous chute extending from her warehouse. She knew kids used it and did nothing. That fits the doctrine.
But there's that important exception
Yeah.
involving parents.
Yes. Examiners love this. The attractive nuisance doctrine might not apply if the child's parent is present and supervising. The idea is the duty shifts to the parent.
Like the case mentioned in her notes, Kelly v. Ladywood Apps. Child injured sledding with dad present.
Exactly. The court said the doctrine didn't apply. The dad had the primary duty of care then.
Okay, landowner duties don't just stop at the property line, do they? What about duty to persons off the land?
Right. Landowners owe a duty of reasonable care regarding dangerous artificial conditions on their land that pose a risk to those outside the property, like adjacent sidewalks or roads. Think a decaying tree branch overhanging the street. Also, for liability for disrepair, if they negligently let an artificial structure fall into disrepair and reasonable care would have fixed it, they can be liable for resulting harm off the premises.
And what about landlord's liability? Isn't the tenant usually considered the possessor?
Traditionally, yes, and landlords had limited liability. But Angela's notes highlight key modern exceptions. If a landlord contractually agrees to repair defects, they must use reasonable care when doing so. Failure can lead to liability.
And some places have gone further.
Yes, some jurisdictions, often by statute, impose a general duty of care on landlords, getting rid of the old common law rules based on tenant control. They just owe a duty of reasonable care to keep the property safe, similar to how some states have abolished the entrant categories. Invitee, licensee, trespasser.
That's a big shift. Makes sense in modern renting situations.
Finally, under specific actors, Angela's notes mention schools.
What's the duty there?
School personnel with supervisory authority have a duty to protect students from foreseeable third-party wrongful acts like abuse or bullying if they know or should know of facts indicating a risk.
But not for completely unexpected, spontaneous stuff.
Generally, no duty for spontaneous assaults unless prior events made them foreseeable. It's about reasonable supervision based on known risks.
Okay, that covers the duty element extensively. What's next in our negligence framework?
Breach of duty. This is where the defendant fails to live up to the standard of care established by the duty. It's the negligent act itself.
How do you prove breach? Sometimes it's obvious, sometimes not.
True. Angela's notes briefly mention res ipsa loquitur, Latin for the thing speaks for itself.
Ah, the doctrine that lets negligence be inferred.
Exactly. It applies when the accident is the type that normally doesn't happen without negligence. The thing causing the harm was under the defendant's exclusive control, and the plaintiff didn't contribute. Think a sponge left in a patient after surgery.
The facts scream negligence, basically.
Pretty much. Her notes also revisit the role of custom in proving breach.
We said custom helps define the standard for professionals.
Right, but it can also be relevant evidence of breach for non-professionals, too. Failing to follow a well-established safety custom in an industry can be evidence of unreasonableness.
But it's just evidence, right? Not conclusive.
Correct. It's distinguished from negligence per se, where violating a statute sets the standard. Custom doesn't have the force of law. Following custom doesn't guarantee reasonableness, and failing to follow it isn't automatically negligent if reasonable care was otherwise taken.
Got it. Custom is relevant, but not the final word on breach.
Okay, so we have duty and breach. Now the crucial link. Causation. How do we connect the defendant's breach to the plaintiff's injury?
This is often where cases get tricky. Angela's notes divide causation into two parts. Actual causation and proximate causation. You need both.
Let's start with actual causation, also called cause in fact. What's the main test here?
The but-for test. This is the workhorse. The test asks, but for the defendant's negligent act, would the plaintiff's injury have occurred?
If the answer is no, the injury wouldn't have happened without the defendant's breach, then the but-for test is satisfied. The breach was a necessary condition for the harm.
And the existence of other but-for causes doesn't let the defendant off the hook, right?
Correct. As long as the defendant's negligence was a but-for cause, that's enough for this element. Angela's notes give the speeding motorist example.
The driver going 57 in a 50 zone who hits a pedestrian.
Right. The pedestrian has to show that, but for the speeding, the negligent act, the injury either wouldn't have happened at all or would have been less severe. Maybe the driver could have stopped in time or the impact would have been less forceful.
So you have to link the specific breach, speeding, to the outcome.
Exactly. Now, what if the but-for test is hard to apply, like when there are multiple potential causes?
That's where the substantial factor test comes in. This is often used when you have multiple forces, and maybe each one alone would have been enough to cause the harm.
Like the example in her notes about the two motorcycles.
Yeah, two motorcycles scare a horse-drawn carriage horse, injuring the driver. The noise from either motorcycle might have been enough to spook the horse.
Making it hard to say that but for motorcycle A's noise, the injury wouldn't have happened because motorcycle B's noise might have done it anyway.
Exactly. In that situation, you ask if each defendant's negligence was a substantial factor in bringing about the harm. If yes, then actual causation is met for both.
Her notes also mention that case discussed in class, Lasley v. Combined Transport,
where the defendant's act was found not to be a but-for cause, but the issue became whether it was still a substantial factor.
Right. It shows how the substantial factor test can sometimes establish causation even when the but-for test fails, especially in situations with multiple sufficient causes or commingled causes.
Okay, so that's actual cause. But for or substantial factor, what's the second part of causation?
Proximate causation or legal cause. This is less about physical connection and more about policy and foreseeability. It asks, should the defendant be held legally responsible for this harm even if they were a but-for cause?
It's like a fairness check. Is the harm too remote or bizarre compared to the negligent act?
Kind of. The key concept is foreseeability. Was the type of harm suffered by the plaintiff a reasonably foreseeable consequence of the defendant's negligent conduct?
What about intervening forces? Things that happen after the defendant's negligence but before the injury?
An intervening force generally won't break the chain of proximate cause and become a superseding cause, which would cut off liability, if the intervening force itself was reasonably foreseeable.
So, if the defendant's negligence created the risk of that intervening force happening?
Exactly. Or if the result caused by the intervening force was foreseeable. Angela's notes have that example about the coal company piling refuse near a stream.
They piled it negligently.
Right. It was foreseeable the refuse might wash downstream and cause harm. Then, an unforeseeable cloudburst caused a massive flood.
Did the unforeseeable flood break the causal chain?
No. The court found the coal company liable because the flood just accelerated and increased the harm that likely would have resulted in any case. The type of harm, damage from downstream refuse, was foreseeable even if the manner, giant flood, wasn't. The defendant is often liable for foreseeable consequences, even if brought about in an unforeseeable way.
So, proximate cause is really about whether the harm was within the scope of the risk created by the defendant's negligence.
That's a great way to put it. Okay, duty, breach, actual cause, proximate cause. What's the final element?
Damages. The plaintiff has to prove they actually suffered legally cognizable harm. No harm, no foul, even if the defendant was negligent.
What kind of harm qualifies?
Well, physical harm is the most common and readily compensable. This includes bodily injury and things flowing from it, like medical bills, lost wages, or impaired earning capacity, and pain and suffering.
And importantly, emotional distress resulting from physical injury is usually recoverable too, right?
Yes. Angela's notes give that powerful example of the friend in a fatal car crash who suffered serious physical injuries and PTSD.
The friend could recover for both.
Yes, because the PTSD stemmed directly from the physical harm and the traumatic event causing it. It wasn't standalone emotional distress.
Okay. What about purely financial harm?
That's economic harm. Things like lost profits, damage to property value, lost business opportunities, recoverable if proven.
Now, the tricky one, emotional distress without physical harm. This falls under negligent infliction of emotional distress, NIED.
NIED. Always a tough area. What are the general requirements?
It typically requires that it was reasonably foreseeable that someone in the victim's position would suffer severe emotional distress due to the defendant's negligence.
And the breach must actually and proximately cause the victim to suffer severe emotional distress. Some courts require a diagnosed mental disorder.
Others might infer severe distress from the circumstances, but it has to be more than temporary fright or minor upset.
And Angela's notes mention it's unlikely you can recover for NID just based on fear of future harm, right?
Mm-hmm.
Like the asbestos exposure example. If you haven't gotten sick yet, you generally can't sue just for the fear you might someday.
Correct. The harm usually needs to be more immediate or already manifested, but there are some special circumstances where recovery might be allowed, even without physical impact.
Like mishandling a corpse.
Yes. Her notes mention a morgue negligently misidentifying a body, causing severe distress to the family. The nature of that negligence makes severe emotional distress particularly foreseeable.
And what about bystander recovery? Someone who witnesses a horrific injury to a loved one.
That's another specific NIED scenario. Rules vary by state, but often require the bystander to be closely related to the victim, be present at the scene, and suffer severe emotional distress as a result of observing the event. Some jurisdictions are even expanding this to allow recovery for unmarried cohabitants if the relationship is stable and significant.
And Angela's notes mention something about parents recovering for a loss of consortium for injured children.
Yeah, historically that was limited, often only fathers recovering for lost services. But her notes indicate a strong modern trend toward recognizing claims by parents for the loss of their child's companionship due to injury, though it's still evolving.
Okay, that covers the elements of negligence. Now, just like with intentional torts, we need to discuss defenses to negligence.
Crucial. Even if the plaintiff proves all four elements, a defense can prevent or reduce recovery. First, the old one, contributory negligence.
The one where if the plaintiff is even 1% at fault, they get nothing.
Traditionally, yes. In the few states that still follow pure contributory negligence, any fault by the plaintiff completely bars recovery. It's a harsh rule. And remember, Angela's note stress it's no defense to intentional torts.
But there was that exception. The last clear chance doctrine.
Right. It softened the harshness of contributory negligence. If the defendant had the last clear opportunity to avoid the accident, the plaintiff's earlier negligence might be excused.
How it applies depends on the situation, right? Helpless plaintiff versus inattentive plaintiff.
Exactly. Courts looked at whether the plaintiff was in helpless peril, couldn't escape, or inattentive peril, could have escaped but didn't notice, and whether the defendant knew or should have known of the plaintiff's peril and could have acted. The specifics varied by jurisdiction.
Okay. What's another defense?
Assumption of risk. This can be express, like signing a waiver, or implied, where the plaintiff voluntarily proceeds despite knowing and appreciating a specific risk.
Like going to a baseball game and knowing you might get hit by a foul ball.
That's the classic implied assumption example. But like contributory negligence, Angela notes it's no defense to intentional torts. And the plaintiff must have actually known of the risk and voluntarily encountered it.
But these defenses, contributory negligence and assumption of risk, they've been largely replaced or modified in most places, haven't they?
Yes, by comparative negligence. This is the modern approach you'll see in most states.
How does comparative negligence work?
Instead of barring recovery completely, it reduces the plaintiff's damages based on their percentage of fault. So, if a plaintiff is found 20% responsible for their own injury, their damage award is reduced by 20%.
Much fair, seems like.
Generally considered so. There are different versions: pure comparative, plaintiff recovers something even if 99% at fault, and modified comparative. Plaintiff recovers only if their fault is less than, or in some states, not greater than, the defendant's fault. But the key is allocation of fault, not a complete bar. It also tends to absorb the concepts of last clear chance and implied assumption of risk into the overall fault analysis.
Okay, that wraps up negligence. Let's move into areas where fault isn't the main issue: strict liability and products liability.
Strict liability, liability without fault. Why impose that?
Usually because the activity involved is inherently dangerous or involves certain things like dangerous animals or defective products, where society decides the actor should bear the risk regardless of care taken.
It's about the nature of the activity or thing, not the conduct. Angela's notes give that example about the farmer's cow.
The escaping cow.
Yeah. A farmer owned a cow. Without any negligence, the cow escaped, broke through a neighbor's fence, trampled the garden, and shoved the neighbor down, breaking his arm.
And the farmer was liable, even though he wasn't careless.
Likely strictly liable for both the property damage and the personal injury. Trespassing livestock causing foreseeable harm often falls under strict liability.
What about wild animals?
Keepers of wild animals are generally strictly liable for harm caused by the animal's dangerous propensities. Her notes also mention indigenous wild animals. If you bring so many onto your property that they become a nuisance, you could be liable, even if they're native.
And for domestic animals, like dogs, there's that one free bite rule.
Sort of. It applies to domesticated animals, livestock, and even wild animals. If the animal shows an unusual, dangerous propensity for its species, like a dog biting aggressively, and the owner knows or has reason to know about it, they can be strictly liable for foreseeable harm caused by that propensity. The one bite idea is just shorthand for the owner needing notice of the danger.
So once your dog bites someone, you're on notice, and future bites might trigger strict liability.
Essentially, yes. Okay, now let's narrow the focus to products liability. This is huge for the bar.
Liability for defective products causing harm. How can a seller or manufacturer be held liable?
Several theories. Angela's notes mention representation theories first. This includes express warranty if a seller makes a specific factual promise about the product that turns out false and the buyer relies on it.
Like saying a ladder can hold 500 pounds, but it breaks under 300.
Exactly. Also, misrepresentation of fact, making a false statement about a material fact concerning the product. Importantly, her notes say any consumer, user, or bystander can sue under these theories sometimes, not just the original buyer. Privity isn't always required.
Okay, besides false statements, what about the product itself being defective?
Three main types of defects: manufacturing defects, design defects, and inadequate warnings. For defective product standards, Angela's notes use that classic chicken enchilada example.
The customer choking on a bone, how's it analyzed?
Well, the old foreign natural test might say a chicken bone is natural to chicken, so no defect. But the more modern, widely used test is the reasonable consumer expectation test.
What would a reasonable consumer expect to find in that product?
Right. Would a reasonable consumer expect a potentially harmful bone in a processed enchilada? Probably not. So under that test, it could be defective.
What about evaluating if a design is defective?
Courts often use a risk utility test. They look at factors like the magnitude and likelihood of harm from the design, whether there was a reasonable alternative design that was safer and economically feasible, the usefulness of the product, and consumer expectations, including those shaped by marketing.
It's a balancing act.
Definitely. Her notes also mention inherently dangerous products: guns, knives, chainsaws. Some courts won't find a design defect if the injury comes solely from the dangerous aspect that's essential to its function.
Like the chainsaw example, a carpenter injured by the cutting chain.
Right. He likely couldn't prove a design defect just because that's what chainsaws do. The danger arose from its essential intended function, not a flaw.
Okay, what about warnings and instructions? When is a warning defective?
A warning might be inadequate if it doesn't reasonably inform the user of significant risks, or doesn't tell them how to avoid the harm. But manufacturers don't have to warn of obvious dangers.
Like the flammable adhesive example in her notes. The label warned to extinguish any nearby sources of flame.
Yeah, and the homeowner got injured when fumes ignited from a pilot light. The court likely wouldn't find a defective warning because a pilot light is a pretty obvious source of flame covered by the general warning.
But a warning isn't always enough, right? Angela's outline had a point about that.
Crucial point. If a reasonable action other than or in addition to a warning would make the product safer, like a better design or a safety guard, the manufacturer must take that action. You can't just warn away a danger you could have easily designed out.
Good to remember. What's the effect of complying with safety laws?
Role of compliance with statutes and regulations. Violating a product safety statute might mean the product is defective per se. Compliance with regulations is evidence the product isn't defective, but it's not conclusive. A product could meet minimum standards but still be unreasonably dangerous.
What about sellers in the middle, like retailers?
Under strict liability, intermediate sellers are generally liable just like the manufacturer if they sell a defective product. But for negligence in products liability, there's a bigger distinction. Retailers usually aren't liable unless their own negligence contributed, like improper handling or failing to inspect when they had a reason to.
And suppliers of individual parts. Component supplier liability.
A component supplier can be liable if the component itself is defective, or if they substantially participate in integrating the component into the final product. That integration causes the defect and harm results.
Then there's the learned intermediary doctrine, mostly for prescription drugs. Yes, and medical devices. The manufacturer's duty to warn is typically fulfilled by adequately warning the prescribing physician, the learned intermediary, who then has the responsibility to assess the risks and benefits for the specific patient. The warning usually doesn't have to go directly to the patient from the manufacturer.
And finally, what if the company that made the defective product gets bought out? Liability of successors.
Generally, a company that just buys the assets of another company is not liable for the old company's defective products. Liability only attaches in limited circumstances, like if the successor expressly agrees to assume liability, or if the sale is basically a merger in disguise, a de facto merger, or a mere continuation of the old business. These exceptions are narrow.
Wow, products liability has a lot of facets.
It really does. Okay, let's move on to other key torts and concepts covered in Angela's notes. How about nuisance?
Nuisance. Interfering with someone's enjoyment of their property or with public rights.
Right. Her notes distinguish between public nuisance and private nuisance. Public nuisance affects the community rights, health, safety, morals. A private citizen usually can only sue for public nuisance if they suffer some special harm different from the general public.
And private nuisance.
That's about a substantial and unreasonable interference with an individual's private use and enjoyment of their land. The interference has to be significant, something a normal person would find offensive or annoying.
And if it's intentional interference, it also has to be unreasonable, right? Balancing the harm versus the utility of the defendant's conduct.
Exactly. And her notes mention the sensitivity of the plaintiff. Generally, the harm standard is objective. Would a reasonable person be bothered?
So if you're uniquely sensitive to noise, your neighbor's normal activities might not be a nuisance, even if they bother you.
Probably not. But if the conduct would bother most people, like pervasive, foul odors from a nearby factory making life miserable for everyone, that's likely a substantial interference. Like the slaughterhouse example, making life unendurable for most residents.
Okay, that makes sense. What about vicarious liability? Holding someone responsible for someone else's tort?
This comes up a lot, especially with employers. Vicarious liability means one party is liable for another's tort simply because of their relationship, even if the first party did nothing wrong themselves.
But it doesn't let the actual wrongdoer off the hook, does it?
No, Angela's notes stress the effect on ultimate responsibility. It does not absolve the primary tortfeasor. Both the vicariously liable party, like the employer, and the primary tortfeasor, the employee, are typically jointly and severally liable. The plaintiff can potentially recover the full amount from either one.
The most common example is employer-employee liability under the doctrine of responded superior.
Latin for let the master answer. An employer is vicariously liable for torts committed by their employee if the torts occur within the scope of the employment relationship.
And what defines the scope of employment?
It's generally about whether the employee was doing the kind of work they were hired to do during work hours and in a location reasonably related to the work, and whether the act was motivated, at least in part, by a purpose to serve the employer.
What about breaks or small personal errands during the workday? The frolic or detour rule?
Right. A minor deviation from the employer's business for a personal purpose is often considered a detour and still within the scope. But a substantial deviation in time or geography for purely personal reasons is a frolic, taking the employee outside the scope, and the employer isn't liable. Distinguishing them is classic exam fodder.
And the key factor in determining if someone is an employee versus an independent contractor is control, right?
Yes, Angela's notes say the degree of control is paramount factor. Does the employer have the right to control not just the end result, but the means and methods of how the work is done? That's the hallmark of an employment relationship. The label the parties use, employee versus contractor, isn't decisive.
What about leased employees? The borrowed servant doctrine.
When one employer lends an employee to another, generally the employer who has the primary right of control over the employee at the time of the tortious act is the one vicariously liable. Usually that's the borrowing employer.
Okay. Now, the general rule for independent contractors is no vicarious liability for the hiring party, right?
Correct. If you hire an independent contractor, you generally don't control how they do the work, so you're not liable for their torts. But there are important exceptions.
Such as?
First, the rule doesn't apply if the employer's own negligence contributed, like negligently hiring an obviously incompetent contractor. That's a direct liability, not vicarious.
What else?
Second, inherently dangerous work. If the work itself carries a peculiar risk of harm that requires special precautions, or risk even if done carefully, the employer can be vicariously liable for the contractor's torts. Think blasting, working with high-voltage lines, maybe using armed security guards.
The risk is so high, the employer can't delegate away the responsibility.
Exactly. And third, non-delegable duties. Some duties are considered so important, often related to public safety or imposed by statute, that the employer remains liable even if they hire an independent contractor to perform them. Like a business's duty to keep its premises safe for customers or a municipality's duty to maintain roads. These are determined case by case, jurisdiction by jurisdiction.
Those exceptions are key. It's not always safe to assume no liability for contractors.
Definitely not. Okay, just touching on a few related concepts Angela's notes mention. Multiple defendants, joint and several liability, we talked about that, allowing recovery from any liable defendant. Also, tort immunities.
Like governmental immunity or immunities between family members, though those are eroding.
Right, historical shields from liability that are becoming less common, and survival on wrongful death actions.
Allowing claims to continue after someone dies, either for the harm they suffered before death, survival, or for the family's loss due to the death, wrongful death.
Exactly. Okay, now let's tackle two big torts protecting reputation and privacy: defamation and invasion of privacy.
Starting with defamation. Injury to reputation. What are the key elements?
First, there must be a defamatory statement, one that harms reputation. Second, it must be of and concerning the plaintiff. Third, it needs publication.
Publication meaning communicated to a third party.
Yes. Communicated to at least one person other than the plaintiff, and that third party must understand the defamatory meaning. Angela's notes had that clever example.
The lawyers speaking French.
Yeah, a lawyer speaks French to another lawyer, falsely accusing a judge of taking bribes. If the second lawyer doesn't understand French, there's no publication. Even if the judge overheard and understood, the communication has to be understood by the recipient.
Interesting nuance. What about distinguishing fact versus opinion, insult, or hyperbole?
A defamatory statement generally must assert a fact that can be proven true or false and harms reputation. Mere name-calling, insults, or obvious exaggeration usually doesn't count. The key is whether a reasonable third party would perceive the statement as asserting fact.
So context matters a lot.
Hugely. Then there's slander per se. Slander is spoken defamation. Usually you need to prove special damages, actual financial loss, for slander.
But slander per se doesn't require special damages.
Correct. Damages are presumed if the spoken statement falls into one of four categories. 1, accusing of a serious crime. 2, having a loathsome disease. 3, harming someone in their business, profession, or trade. Or 4, accusing of serious sexual misconduct. Those are considered so damaging that harm is assumed.
What about public figures? Rules are different for them, right?
Okay.
Constitutional limits.
Yes, big difference, stemming from New York Times v. Sullivan. Public officials and public figures, both general purpose, like celebrities, and limited purpose figures involved in specific controversies, must prove the defendant acted with actual malice.
Actual malice meaning the defendant knew the statement was false or acted with reckless disregard for its truth or falsity. A very high standard.
Extremely high. For private figures suing over matters of public concern, they generally need to prove actual malice only for presumed or punitive damages. Negligence might be enough for actual damages. For private figures and matters of purely private concern, the constitutional limits are lower, and state law, often requiring just negligence, usually applies.
That distinction is crucial for exams.
Okay.
Defenses to defamation.
Truth is an absolute defense. If the statement is true, it can't be defamatory. Consent is also a defense. And then there are privileges.
Absolute and qualified.
Right. Absolute privileges provide complete immunity, regardless of motive. Examples include statements made during judicial proceedings, by legislators during debates, and, as Angela's notes mention, communications between the spouses, that historical remnant, and communications required by law, like those political broadcasts.
And qualified privileges.
These provide immunity only if exercised reasonably and for a proper purpose. They can be lost if abused, for example, by acting with malice or excessive publication. Examples include statements made to protect one's own interests, the interests of others, like credit reports or common interests, and the public interest privilege mentioned earlier, like reporting suspected crimes. The reporter example in her notes showed how failing to be fair, not reporting the refutation, could lose the privilege.
Okay, that's defamation. What about the other invasion of privacy torts?
There are generally 4 types recognized. First, intrusion on plaintiff's affairs or seclusion.
This is about the act of prying itself.
Exactly. Intentional intrusion into someone's private matters, physical space like home, or private information like mail or bank accounts, in a way that would be highly offensive to a reasonable person. The key is the intrusion into something genuinely private. Taking photos in public generally doesn't count.
Second type.
Publication of facts placing plaintiff in false light. This is putting someone before the public in a way that attributes to them characteristics, conduct, or beliefs they don't hold, and doing so would be highly offensive to a reasonable person. It requires publicity communication to the public at large.
Like the taxi driver photo example.
Mm-hmm.
Putting her picture next to an article on fraud, implying she was involved when she wasn't.
Precisely. It creates a false impression, even if not strictly defamatory.
Third.
Public disclosure of private, truthful facts. This involves publicizing genuinely private facts about someone, where the disclosure would be highly offensive to a reasonable person and isn't of legitimate public concern. The facts must truly be private, not already public knowledge. This tort is tricky because it involves truthful information.
And the fourth, appropriation.
Essentially, yes, though Angela's notes frame the defense side. Permissible incidental use. The main tort is appropriation of name or likeness for commercial advantage. But there's no liability if the use is merely incidental or for news reporting commentary purposes rather than exploiting commercial value. Especially true for public figures.
Got it. 4 distinct ways privacy can be invaded.
Okay, let's quickly cover a few more torts from Angela's notes. Interference with business relation.
Intentionally messing with someone else's contracts or potential business deals.
Right. This can involve inducing breach of an existing contract or improperly interfering with a prospective economic advantage. Defenses often involve privileges like legitimate competition.
The misrepresentation. We touched on this under products liability, but it's broader.
Yes. Intentional misrepresentation, fraud deceit, involves knowingly or recklessly making a false statement of material fact, intending to induce reliance, causing the plaintiff to justifiably rely and suffer damages. Generally no duty to disclose, but her notes highlight the exception for sellers of homes needing to disclose known hidden material defects.
And negligent misrepresentation.
Much narrower scope. Usually applies only in business or professional contexts, where someone supplies false information for the guidance of others in their business transactions and fails to exercise reasonable care. Liability is often limited to harm suffered by those the provider intended to reach and influence, like the consultant example praising the insolvent title company.
Okay, nearly there. Malicious prosecution.
Initiating criminal proceedings against someone without probable cause and for an improper purpose, which terminate favorably for the accused. Her notes stress an officer relying reasonably on a credible witness at the time isn't usually liable, even if the witness later recants.
And wrongful use of civil proceedings is the civil lawsuit equivalent.
Basically, yes. Bringing a civil suit without probable cause and for an improper purpose, like harassment.
An abusive process. That's different. Yeah.
Yes. It's not about wrongfully starting the lawsuit, but about misusing a specific legal process within litigation, like a subpoena, attachment, garnishment, for an ulterior, improper purpose collateral to the litigation itself. Using a subpoena to extort money, for example. Pressuring for settlement within the case usually is an abusive process.
Okay, finally, let's talk remedies, specifically punitive damages and injunctions.
Punitive damages. These aren't about compensating the plaintiff. They're about punishing the defendant and deterring similar conduct in the future.
When are they awarded?
For conduct that is more than just negligent, usually requires reckless indifference to others' rights or malicious, willful, or wanton conduct, conscious disregard of a high risk of harm, Angela's notes emphasize no punitive damages for mere negligence, and likely not even for gross negligence unless it rises to recklessness.
And there are constitutional limits on the amount, right? The ratio issue.
Yes, the Supreme Court requires the ratio between punitive and compensatory damages to be reasonable, considering due process. A single-digit ratio is more likely to be upheld, but it depends on the egregiousness of the conduct and the actual harm.
And permanent injunctions. Ordering someone to stop doing something.
Right, an equitable remedy. Granted, when money damages are inadequate, the court must find the balance of harms weighs in the plaintiff's favor. The harm to the plaintiff without the injunction outweighs the hardship to the defendant if it's granted. The party's conduct and motives also play a role.
So it's a balancing test by the judge.
Exactly. Whew. So what does this all mean? We've just taken a whirlwind, yet hopefully deeply detailed, tour through the vast landscape of torts.
From intentional wrongs through the huge area of negligence, defenses, strict liability, products liability, nuisance, defamation, privacy. It's a lot.
It really is. But it's clear that Angela's notes offer an incredibly detailed roadmap for navigating these complex legal waters, hitting both the big picture concepts and those crucial nuances you need for bar success.
As we wrap up this deep dive, we want to remind you, as future legal eagles, something really crucial. The paramount importance of evidence.
Good point. Knowing the rules is one thing.
But in all these torts, proving your case, establishing those elements, we painstakingly went through duty, breach, causation, damages, intent, whatever it is. It all hinges on strong, compelling evidence.
So the important question for you is, how are you going to spot and use that evidence effectively, both on the bar exam hypotheticals and eventually in practice?
It's not enough just to know the black letter law. You have to apply it precisely to the facts, drawing those direct lines. That's where you really show your understanding.
Absolutely. And we really have to say a huge thank you again to Angela for her incredible torts notes. They truly are the blueprint for understanding this massive subject, and were our essential guide for this deep dive.
Agreed. Okay, before we sign off, some important housekeeping points.
Right. First, just a reminder, Angela is a student, just like you. She's brilliant, obviously, but she's not a licensed attorney or expert, and she hasn't passed the state bar yet. We're sharing her learning journey and insights.
Second, neither Angela nor this deep dive is giving legal advice. Please don't construe any of this as legal advice. And remember, AI like us, well, we aren't a substitute for your own hard work studying the law. Keep hitting those books and outlines.
Third, AI isn't always perfect. Sometimes we make mistakes. While Angela does her best to ensure the accuracy of her materials, and we try to be accurate based on them, always double-check things against your casebooks, statutes, and other study aids. Critical thinking is key.
And fourth, and maybe most importantly, if you're listening to this in your car, please prioritize safety.
Yes. If learning about proximate cause or the nuances of landowner duties is going to distract you from driving safely, please hit pause, listen later when you can focus.
Seriously, don't cause a tort while listening to torts.
Couldn't have said it better myself.
Okay, and if you need to contact Angela for the podcast or about her freelance law clerk work,
the emails again are podcast@studyforthebarinyourcar.com or hello@legalwriterandlawclerk.com.
all right. Tradition dictates we can't leave without.
A cheesy lawyer joke? Okay. Why did the jury find the ghost not guilty?
Oh dear. Why?
Because he had no body of evidence.
Simulated groan sigh. Oh, that sounds soft.
That's right. This is Claude and Ma, your AI bot, signing off. See you in the next deep dive.
Goodbye, and thank you.